Hello BADM 107 students. This video will review in advance of the midterm exam, and what we're going to do is we're going to look at last year's midterm exam. Now I'm sitting in a different room, so the lighting's a little different, and there's shadows on my faces, so if that bothers you, then don't look at my handsome face. Go back and bring up the midterm exam from summer of 2020, put it on the screen, and then just listen to me in the background. You'll see on that midterm exam that like all my other midterm exams, I have 15 terms, 18 definitions in Part A, and you have to match the best definition to the term and put the letter in the brackets. I do not expect you to memorize perfectly the definitions, otherwise I would just give you alternate dispute resolution and some lines and say fill it in. What I'd like you to do is know concepts, okay? So if you understand that alternate dispute resolution has to do with mediation and arbitration as an alternative to going to court, then you'll be able to look down the list of definitions and find the most appropriate one. Big warning here. In the past, what happens is when there's an online exam, students go, oh man, this is just so cool, all I have to do is just, have the textbook here, or, and look up the definitions and put, and then find them on the list and then put in the numbers, or, I don't even have to use the textbook. I don't know, why am I going to buy the textbook, waste that money? I'll just Google it online. I found that students were taking over an hour of their exam time to do Part A, and that is really putting you under a crunch for the later part of the exam, okay? Part A is designed to give you a good chunk of marks for work that you have done, so that very few of you will fail the midterm exam. The problem is those that spend too much time on it don't get to the other part of the exam, and then they do poorly. So do the index cards, learn the terms, go through the list really quickly. Oh yes, I know this one. Oh yes, I know this one. Oh yes, I know this one. I don't know that one. Leave it out. Oh, okay, I know this one. Oh, I don't know that one. And then once you've got all the terms that you know like that, then you look up the others, and it'll go quickly, and then you're on to Part B. I'm not going to go through the definitions. What I'm going to do is I'm just going to post my answer key online after this is all over, and you can work them out for yourselves if you have a problem. Part B, always the same. I have question 1. You do not know what's coming, and then you have a choice of 4 out of 8 questions for the remainder of Part B. Question 1 is worth 10 marks, the others are worth 5 marks each. If you do question 1 and then you do 5 or 6 or 7, or what the heck, I'll do all 9 questions, and then I'll say, Professor Holden, pick my best ones. Your best ones will be the first 4. Okay, I don't have time to mark 40 times 8, what's that, 40, 320 problems, and then pick your best ones. So I mark question 1, and then I look for the ones that have been answered, and I mark the first 4 of those, and if you get one of those, you only get 2 out of 5, and then on your 5th question, you get 5 out of 5. You're going to be back, oh, please, Mr. Holden, give me the 5 rather than the 2, and my answer will be, no, you should have followed directions. Okay, so question 1, you're a small claims court judge in BC, and there are a number of cases on the docket today, and you have to make a decision and give your reasons for judgment. Sounds scary, but this is just saying, is there a contract or not? Okay, and you should be able to answer that. So the first one is the Quickie Mart grocery store in Springfield, BC, so you know it's BC law, has been robbed on a number of occasions over the past few months. Sergeant Murphy of the Royal Springfield Foot Police told Baumlinger that he had been assigned to patrol the neighborhood and to specifically keep an eye on the store. Bertha said she was glad that the sergeant would be on patrol and offered O'Doul $1,000 on top of his regular police salary for doing the job. A few months later, after the police captured the robber and no further hold-ups had occurred, Sergeant Murphy asked for his $1,000, but Baumlinger refused to pay. Sergeant O'Doul sued Baumlinger for breach of contract. Now, the knee-jerk reaction here is to say, oh, she offered, but he didn't accept. That's failing to remember that there are two types of contracts. There's a bilateral contract where she has to offer and he has to accept. And then there's unilateral contracts where she has to offer and all he has to do is perform the requested act. The problem with that, of course, is that there are reasons why there is no contract. Okay, so O'Doul sues Baumlinger, who wins. The case is dismissed, so the court finds in favor of Baumlinger. Why? Murphy is already under a legal duty to perform. Baumlinger received no consideration to bind her to the agreement. Okay, so if you're already under legal duty to perform this task, then somebody offers you additional money. You're getting a benefit, but what's the other person getting? They're getting nothing because you're already supposed to be doing that. So it was 1 mark judgment for Baumlinger and 1 mark for giving the the correct judgment. Oh, Velma Vip, claimant versus Bertha Baumlinger. And what we have here is a situation where it's a small claims court matter. And Bertha Baumlinger offered to sell a Davil pivot. Ooh, what's a Davil pivot? Who cares? Okay, it's just something. To Velma Vip for $18,000. Velma very much wanted the Davil pivot and was willing to pay as much as Bertha wanted, but decided initially to offer only $5,999.99. Bertha was insulted by this low offer and refused to sell for that much. Verma said, okay, I'll take it for $18,000, but Berma now refused to sell for that amount. Verma said, you offered at $18,000, I'm holding you to that offer because I accepted it. Still Bertha refused, so Vip sued Baumlinger. In court, judgment for Baumlinger again. Good, Baumlinger's doing okay so far. Why? There was an offer for $18,000 and Vip accepted it. Well, Vip's counter offer of $5,999.99 extinguished the $18,000 offer made by Baumlinger, and it's no longer available to be accepted unless it's reiterated. So 1 mark for Baumlinger, 1 mark for counter offer. All right, the next one is J. Montgomery Burns, claimant, versus Melvin Bellows, defendant. Melvin Bellows, affectionately known as Mouthpiece Mel Bellows by his supporters, was mayor of Vancouver. He owed J. Montgomery Burns, the CEO of Mega Stores, Inc., $125,000. Bellows wrote to Burns and said that the last mayoralty campaign expenses had been much higher than he anticipated, therefore he could not afford to pay Burns the full amount of the money he owed him. Mouthpiece Mel could, however, pay up to $80,000 if Burns was willing to accept that amount in full and final satisfaction of the whole amount. Burns wrote back, agreeing, but after Bellows paid the $80,000, Burns sued him for the balance, claiming that his promise to accept part payment was only a gratuitous one. Okay, a gratuitous one is where someone's not getting any consideration. And so, I'm owed $125,000, you say I'll pay $80,000, I say okay, I get the $80,000, what consideration have I got? You got the consideration supposedly that you're only paying part payment. But what did I get? Well, I got less than I was owed. Okay, so I'm not getting any consideration. So obviously there is a potential here under the law of condition in contracts that Burns would be able to sue for the amount. However, Bellows wins. Why? Because in the province of British Columbia, Section 43 of the Law and Equity Act says no new consideration is necessary as long as Burns expressly accepts. Okay? Don't just say, oh, because Burns accepted, because Burns, without the Law and Equity Act, just accepting means he would be able to sue for the balance. Okay? You actually have to specifically say, that it's Section 43 of the Law and Equity Act. No consideration is necessary as long as Burns expressly accepted, which he did. Okay, and that's part payment of a debt. The Folks versus Beer case that we went through and how the BC laws changed it. I told you it was going to be on the exam. Or I told those students that it was going to be on the exam, and it will be on the exam. And I've told you that it's going to be on the exam, and it will be on the exam, either in question 1 or part A, or it'll be somewhere else. Okay, then we go on to a really, really fun one. It's worth 4 marks. Bertha Baumlinger, oh, poor Bertha Baumlinger, she's been sued 3 times. Has further legal problems. She read in the Vancouver newspaper that the Prime Minister of Canada, Justin Trudeau, planned to introduce legislation in the House of Commons to ban automatic assault weapons. Weeks later, Bertha had obtained, just weeks earlier, she had actually obtained the necessary permits and had legally bought an M16 assault rifle to protect herself and her Quickie Mart grocery store from the armed robberies before the police apprehended the culprit. Baumlinger wanted to keep her assault rifle and was so upset that she exclaimed, "Good golly gee, I wish that some honorable personage would do me the favor of poking that windbag in the eye. If so, I offer to pay him the most handsomely." Bart Baumlinger, Bertha's 16-year-old son, was in the Quickie Mart, heard what Bertha said. Bart said, "I accept your offer, Mum," and he flew to Ottawa, Ontario, and gave the Prime Minister a black eye. After Bart Baumlinger was released from jail, because that would be a crime, okay, and we're not concerned with crime on this exam, he asked for payment, but Bertha refused to pay him. Bart sued her for breach of contract. So obviously, at least hopefully obviously, although some people last year said, oh, well, Bart did what he was supposed to and accepted her offers, so there's got to be a contract. There are 3 reasons why there is not a contract on this one. Okay, first of all, intention to contract. Contracts of minors are generally enforceable by them against the other party, but not by that other party against Bart. So the fact that he's 16 years old was a red herring, and a whole bunch of people grabbed onto that. It's a minor's contract. No, he could enforce it if it was a legal contract. Okay. However, first thing is it's legality of object. Okay. You cannot have an enforceable contract for the commission of a crime, and that's the offense of battery. The other reason why it's not enforceable is Bart and Bertha are son and mother, and we know from the Balfour versus Balfour case, actually we know from the second one, under intention to create legal relations, that a contract between a son and a mother the court presumes there's no intention for that contract to be legally binding. The third reason why there is no contract is because of, again, intention to create legal relations, but this time it doesn't go to a contract between the mother and son. It goes to the fact that this was an exclamation of an excited person rather than a real offer. Okay, so those are the reasons why there is no contract. Now, there was a potential for a bonus mark here. I thought about this afterwards. Although not part of the action for the alleged breach of contract, there is a constitutional issue involved in the facts of this case, and the judge elected to express an opinion on the issue, which means you're supposed to, okay? And that is a ban on assault rifles, weapons, which is property, falls within Section 92 of the Constitution Act of 1867. And is not within the purview of the federal government. It would be the provincial government, so it would be ultra vires the powers of the federal government to pass that legislation. Now, oh my gosh, how could I possibly know that? Well, when I was talking about ultraviaries in constitutional matters, I specifically used the example of the federal government's attempt to pass gun control legislation and how all 10 provinces in the 3 territories challenged the federal government's right to do that, and because the matter would be ultraviaries the powers of the federal government. Under Section 92 of the Constitution Act, the provinces have control of civil and property rights. Civil rights is not against discrimination. You can't take away my rights to a fair trial. No. That's not what it means. Civil means private law matters. Okay, and ownership of guns and registries and things like that are private law matters. All right, so I'm just going to quickly look. Question 2, human rights, pretty straightforward. Torts, straightforward. Fiberglass sheets. Yeah, that's pretty straightforward too. If you have any questions on any of these, because you look at my answers and you go, I don't understand that, then you email me, okay? Signing of the Magna Carta, obviously that was on there because I told you how big I am on that with the assault on rule of law in the United States. Tort of trespass, ethical and legal implications of forcing another party to sign a contract with a mediation and arbitration clause, straightforward. You're a BC Supreme Court judge hearing a case in which Peak Performance Pontoons is trying to enforce a restrictive covenant. Okay, this is really important because I glossed over legality of object because it's relatively straightforward as an element of a binding contract, although one case was specifically comes up a lot is restrictive covenants, which you would think would be offensive because they lessen competition, but it comes up in purchase and sale of businesses, on hiring employees, and contracts between businesses. And so I said, what are the steps the court takes in a situation like this? The first thing they do is they say the clause is prima facie void as it restricts competition. And then they look to see if there's a public policy reason why it should not be enforced. So you do not get past 1 if 2 is there. But if there's no public policy reason, then you can actually get around the prima facie void by rebutting that presumption, because prima facie void means on the face of it. So, initially when we look at it, it's void unless there's some reason why it should be enforceable. So you can rebut that presumption. And if you are able to say, well, look, I've built up a lot of goodwill in my business, and if I could not provide a restrictive covenant to a purchaser, the purchaser would never buy it for the value of the business because I would be able to compete against him, and he would be buying nothing except my equipment. And the other side, the person says, well, I would not pay the full value of that business if that person could compete against me. I would just buy the assets, and then they would not get a reward for all their hard work. So then you rebutted the presumption, and then the fourth step, the court looks to see if the restrictive covenant is reasonable with respect to time, the area covered, and the nature of the business restricted. Okay, that is part A and B taken care of. Now I'm going to look at part C. And I tell you, last term, part C, the answers were, to be honest, pathetic. And the reason is twofold. Number one, students said, I can just Google the answers to these other things, or I can sit there with a textbook and restrictive covenant. Okay, I can open that up and read it, okay, and then answer it. And you just do not have the time for that. It is an open book exam, which allows you to prepare better, but the students didn't. Okay, and then the other reason is that when I said, let's do this practice problem, only the last version, students said, oh, well, he's going to give us the answers anyway in the video, so like, what do I have to look at it for? And so in part C, I'm going through and I'm saying, oh, okay, there is a person walks in and slips on wet floor and falls and injures themselves. So that's occupier's liability. And the students sit there and thinking, oh yeah, okay, sure, yeah, sure, I saw that. Yeah, sure, I can see that now. And then there's somebody else wants to buy something and it's an invitation to treat. Oh, of course, yeah, invitation to treat. Well, you'll see them all if you're listening to me point them out. But on your exam, I'm not going to be there saying, oh, you missed one. Go back. Look, there's one. Okay, and the next one is this. The next one is this. You got to find them yourself. Okay, so if you did not do this problem ahead of time, then you'd better really hit the books and study hard, because you will not be prepared enough for the exam. Okay, the people were getting 8 and 10 and 12 out of 40 on Part C because they didn't leave enough time and because they thought that they didn't have to review it because, oh, gosh golly gee, I mean, I'm there, aren't I? And, I'm in, I'll give you the answers, but I don't. All right. Having said that, which sounds a little condescending, and I apologize for that, particularly to the people that actually did the problem, let's look at Part C of the exam, and I'm just bringing it up on the screen. Okay, I need my answer guide on the screen. That's what I need. Sorry about that. So I'm just going to get rid of that part and go in to exam review and bring up the Grogan marking guide. Okay, so my recommendation is that on the left-hand side of the page, you list all the issues. On the right-hand side of the page, you list the principles. So you're going through the exam, you think the issue, I can't remember the principle, leave it blank, come back to it later. But go through and list all the issues that you can see and give all the principles that you can remember, and then go back and start looking in the book and filling in the blanks. Myrtle Grogan decided to open up a small scuba diving gift shop, and she found a place on the dock, and she comes into her office or business one morning and almost slips on the wet steps at the back. Now, business people don't come in the back, so is that an issue? No, it isn't, but what it does do is it relates to the fact that if she knows it's wet at the back, she should know that the entrance might be wet at the front, okay? So then we go on a little farther. One of her most recent customers returned a mug and demanded her money back because Myrtle was using a lead-based lead glaze, which was probably poisonous. Okay. Myrtle refused or refunded the customer the money, but decided to continue to sell the remainder of the mugs left in stock before changing the glaze. All right, what's the issue here? Well, the issue here is that it may be that the mugs were negligently manufactured. Okay, so that means product liability is the issue. List that on one side, negligent manufacture of goods on the other, and you can see from the marking guide that you'll give 1 mark and 1 mark. She decides to sell them. You can do that. You can sell dangerous things. I sell chainsaws. They're dangerous. I can do that as long as I warn people. So these mugs are decorative, okay? So you sell them and say it has a lead-based glaze, so do not use it for consumption of liquids. Okay, so that's a duty to warn, okay? And you must warn of dangers in the use of the product. A little while later, Phyllis Frumstetter, who was on vacation, came up to the dock to investigate the gift shop. Just as Phyllis was entering the store, she slipped on the wet door jamb and fell, injuring herself. Okay, right off the bat. Oh, negligence. No, it's not necessarily negligence. It's probably more appropriate to look at one of the categories of negligence as it developed over time, because Grogan is the occupier of premises. And so this is really occupier's liability. So that's one mark. And what category does Phyllis Farmsteader fall into? Is she a licensee? No. Is she a trespasser? No. So she must be an invitee. So you get another mark. Then you say you remove dangers of which you are or ought to be aware, and you get another mark. And then if you happen to say, okay, it's Occupier's Liability Act because it's now codified in there, then you get 4 marks. If you decided to say it was negligence, okay, you can do that, and you will get 1 mark for saying it's negligence, and you will get 2 marks for saying you owe a duty of care, the person breached the duty of care and caused the injury. So you'll get 2 for that, so you get 3 instead of 4. Okay. All right. The next thing. Carl Clumsy attempted to come to her rescue, but as he tried to pick her up, he accidentally dropped her, causing her further injuries. Eventually, she was taken to the doctor. Okay, so what about Carl Clumsy? Well, you pick him up and you drop her. That's negligence. Okay. So you would be able to get 1 mark there, and then 2 marks for saying duty, breach, and damages. If you said it was negligence up above, then you'll only get 1 mark for saying Clumsy was negligent, because you don't get extra marks for saying the principle twice. You just say see above. All right. But is he going to be sued? Well, yes, anyone can sue anyone, anywhere, anytime for anything. But will he be liable? No, he will not, because of the Good Samaritan Act in the province of British Columbia, which says if you try to help someone and you're negligent, you will not have any liability. After that bit of excitement, Barry Benz came into the shop and asked to rent a full set of diving gear. Myrtle outfitted him, and after he paid the rental fee, he left the shop. Grogan realized she'd forgotten to get him to sign the waiver, so she races down to the dock and asks him to sign the waiver. He asked what it was, and she explained to him, including all the dangers in scuba diving. Ben says, okay. He signs the form, and as it turns out, Ben's was susceptible to the bends, which is nitrogen bubbles in your bloodstream from raising to the surface too quickly, causes extreme pain and possibly death. He rose to the surface too quickly because the gear failed. Okay, now we don't know if the gear failed because Grogan did not maintain it properly, or whether it failed because it was negligently manufactured. Who cares? That's product liability. All right. So you just put product liability, scuba equipment, 1 mark, and then you see negligent manufacture of goods, and you'll get an extra mark there, even though it's above. I decided to give marks for that. Okay, but there are other aspects here. Number 1 is when you're scuba diving, and something happens, you don't go quickly to the surface. Okay, every scuba diver knows that, and I explained it in the problem, because when he mistakenly swam to the surface too quickly. All right, so obviously that was a mistake, which means he contributed to his own injuries, so it's contributory negligence, 1 mark. And just saying contributed to his own injuries is 2 marks, or is another mark. Now, she did explain all the dangers of scuba diving, so Grogan may have a defense. What's that defense? Volenti non fit injuria, which is voluntary assumption of risk. Okay, people that skydive voluntarily assume that something may happen. Scuba divers voluntarily assume that something may happen, and so it's a defense to the people that are providing services. Then Walt Wiederman came into the shop and bought 10 of the wooden scuba diving figures, brought 10 of the scuba diving figures to the register. He said, I accept your offer, I'll take them. Myrtle then realized the price tag said $2.99 instead of $25.99. She refused to sell the figures to him, but Wiederman said they had a binding contract, so he would sue her if she did not sell them to her at the lower price. Myrtle demanded that he leave the store, and when he refused to do so, she maneuvered his departure by threatening him with a broom. Okay, so many people get assault and battery mixed up, all right? Assault is when someone tries to hit you. Battery is when they make contact. All right? So the first thing here is invitation to treat. The goods on a shelf with a price tag, or goods on a website with a price tag, or goods in a catalog with a price tag, are invitations to the world for people to make offers to buy. Okay? So Wiedemann picks up the figures and brings them to the counter and says, here's the money, contract complete. No. He brings them to the counter and he offers the money. He's making an offer. Okay? And there's no contract until Myrtle Grogan accepts the offer. All right, so goods on the shelf, or 1 mark for saying invitation to treat, and 1 mark for saying the price tag is an invitation, not an offer. So he demands that she sell them, and she says, get out, and he refuses to go. That means there's a trespass here, because trespass is coming onto someone's property wrongfully or refusing to leave. Okay, so it's trespass, unlawfully remaining on the property, 2nd mark, and then she comes at him with a broom. She does not hit him. Ergo, it's an assault. Okay, and it's not because she's coming at him with a broom and trying to hit him. It's assault because he sees her. Okay, it's the apprehension of imminent harmful or distasteful contact. So he thinks he's going to be hit, so he leaves. Now, Myrtle does have a defense against that, and that's use of reasonable force to expel a trespasser. Okay. Meanwhile, down at the gas dock, Myron Entwistle III and his wife Gertrude had just tied up their magnificent 42-foot sailboat called the Typhoon, which means big wind. Bobby Bottomkeel, the young lad at the gas pump who worked for Gas to Go Inc., began to refill the Typhoon while Myron talked to him. Barnacle Bill came down to the dock to admire the sailboat. Just as Gertrude stepped out on the dock in a scanty bikini, Barnacle Bill muttered aloud, "She's well equipped, well rigged, with sleek lines, strong bulwarks, and a clean bottom with no muscles on her." Those are all nautical terms, not naughty terms. Nautical terms means terms related to boats and things like that. But Myron thought that Barnacle Bill was talking about his wife, okay? And so he called Barnacle Bill an old pervert, turning the heads of other onlookers. Then Myron tried to punch him. Barnacle Bill, although surprised, easily hopped out of the way of the ineffectual swing. Now, of course he hopped out of the way, because earlier I described Barnacle Bill as a one-eyed, one-legged old salt. All right, so obviously he couldn't step out of the way; he had to hop out of the way. Ha ha ha! Bad joke. Okay, so Myron tries to hit Barnacle Bill, who then goes and gives Myron a sock to the jaw, knocking him onto his bulwarks, which is the ribs in a boat. Gertrude let out a scream, and with the aid of a well-placed blow with an oar, sent Barnacle Bill into the drink. I'm going to try to remember to explain things. I had a lot of international students who said, "Into the drink? What drink? What was he drinking?" Into the drink means into the water, and I didn't think about that. Cross-cultural communications. Okay. What have we got here? Well, defamation, old pervert. Okay. Now, if you said, "Oh, he said all those things about Gertrude, and that's a defamation," and you put that down, I won't take any marks off. But you're not going to get any marks because it's not a defamation. It has to be something that hurts her reputation, and it's not even directed at her. So if you think you see something, put it down. Okay. So unless you're incredibly wrong and it demonstrates the fact that you know nothing and have not studied, I won't take any marks off. If you said he knocked Myron down onto his bulwarks and that's false imprisonment, I'd probably see red and take a mark off. But I don't take marks off if you think you see something and put it down. Okay, so what we've got here is Myron Swing is an assault. Oh no, it's back to defamation. Old pervert. 1 mark for that. What kind of defamation is it? Slander. 1 mark for that. Published statement causing an unjustified injury to the private, professional, or business reputation of another person, and 1 mark for that. Myron takes a swing. This is an assault. Okay. So you get 1 mark for that. You do not get a mark for the definition. Because you should have put it up above. If you miss the assault with a broom and you say Myron assault, Myron swing, and then you give me the definition there, I will give you the mark. Okay. All right. Then Barnacle Bill jumps out of the way and hits Myron. That's battery. Okay. The merest unconsented to intentional touching of another. You get a mark for that. But Barnacle Bill has a defense. He's defending himself. Okay, so it's self-defense. Get 1 mark for saying that. 1 mark for saying the use of no more force than is reasonably necessary. Gertrude comes and wham, hits Barnacle Bill with an oar and knocks him into the water. That's a battery. Okay, so if you say battery, just put C above for the definition if you've given the definition above. If you haven't given the definition above because you missed the battery from Barnacle Bill, then as I said earlier, you put in the definition there and I will give you the mark. Gertrude does have a defense, and that's the defense of a third party. Okay, she can use no more force than is reasonably necessary to come to the defense of her otherwise ineffectual husband. All right. Then Bobby Bottomkeel hears the sound of the explosion, and he runs to try to help Barnacle Bill with 1 arm and only 1 leg. But, he's not going to be able to swim very well. And he leaves the gas unattended. This is negligence. Okay? An unexplained spark. You might want to put down unavoidable accident because, hey, nobody expected it. Or you might want to just say it's part and parcel of the negligence. Okay. Anyway, negligence. So you get 1 mark for that. If you put negligence up above for Carl Clumsy, then you do not get the marks down here again. But if you didn't do it up above and you put them there, I give you the marks. There is vicarious liability, and vicarious liability will be on the exam. Oh, and by the mention, did I happen to mention that vicarious liability will be on the exam? And before I forget, vicarious liability will be on the exam. And the reason I'm saying that is it's one of the risks of being a business owner. You are always vicariously liable for the torts of your employees. So you do not want to be in a sole proprietorship or partnership arrangement. What you want to do is, if at all possible, if it's applicable, have a corporation, because then the corporation is the employer. One of your employees makes a negligent action, they are liable, but they usually don't have enough money to compensate, so the corporation will be liable, and it may bring the business to an end, but at least it will protect you as the owner of the business. Okay, vicarious liability, very important. All right, gas spills into the harbor. The boat burning is not a private nuisance. Okay, it's a one-shot thing. A private nuisance is something of an ongoing nature, but it is part and parcel of the negligence. But the gas going into the harbor is a strict liability. Okay, you collect gas on your dock, it escapes through no fault of your own, you're liable for all the resulting damages. It's also a public nuisance because the water is used by the public for boating and scuba diving and swimming, and so it's a public nuisance. Interference with the use and enjoyment of public property. The sound of the explosion startled Myrtle Grogan, who ran and hid in the stockroom. Someone said, because that allowed the person to rob the store, she was negligent. Well, okay, that was negligent, but who does she sue? Okay. Herself. No, so obviously it's not. Negligence at law. Okay, a thief in the store sees the opportunity, stealing a box of wooden figures, some diving gear, and the cash from the cash register. Theft, put down theft. Yay, got marks. No, you don't. Okay, the problem says ignore criminal matters. What I want to know is what the tort is. She wants the cash back, she wants the figures back, and she wants, what else did he steal? Some diving gear. She wants that back. How does she get it back? Conversion. Okay, she has to sue the thief. Okay, so you put down conversion, and then you describe it as theft of stuff. Converting the goods of another to one's own use. It's also false imprisonment, right? Because he locks her in there. So false imprisonment, you get 1 mark, and then intentional unlawful confinement, you get 2 marks. Now, there's 3 elements to it, but without the confinement, you don't get false imprisonment. But the confinement has to be intentional and unlawful. So if he was stealing the goods and he didn't know she was in the back room and he was running out the door, and to make a quick escape, he just slammed the door shut, she might be unlawfully in prison, but it wasn't intentional, and he would not be responsible for false imprisonment. Okay, sometime later, she served with 2 notices of claim, one from Frumstetter for occupier's liability and the other from Benz for product liability. She has no idea what to do with them. She headed off to her lawyer's office, but inadvertently left the forms on her counter. So somebody said, oh, well, this is steps in a court action. Okay, sure. So I gave 1 mark for that. And then the other more appropriate answer is that this is the use of your lawyer's time effectively. Take a shopping bag. Okay, you're going to your lawyer's office. Don't go down there and say, oh, I want to talk to you about the notices of claim. Oh, I didn't bring them with me, but I'll tell you what's in them. The lawyer will say, go back and get them. All right, so you can see that there was potentially something like 45 or 46 marks out of 40. Am I concerned that somebody's going to get over 100 marks? No, because you can only get up to 100 marks. But I'm not concerned because of the time crunch, and just because of the nature of the problem. There's only been 1 time in all the years I've been teaching that someone got 40. So that's the problem. So there will be a similar problem. And on that similar problem, you can be sure that there will be a vicarious liability and negligence, because those are extremely important. There are always assaults and batteries. Just go through and list them down, but don't forget to describe where you saw them. Okay. So the problem is there. Just start answering right under the problem, and when I mark it, I'll attach my answer guide. All right, so that's the video in preparation for the midterm exam. But let's just talk about question 1 in part B. Last term, the one we've just reviewed, was a contract problem. It's unlikely that I will give you a contract problem again, but if I can't figure out how to do the others in an open book exam type, I may do it again, but probably not. All right. What I will be doing is looking at maybe a short one with torts, okay, or I will do a short one about steps in a court action, or I could do a short one on the Constitution, which I'm really big on. Okay, so that's a heads up of what those about. Now, as far as Part B exam questions go, as I've been lecturing, as often as possible, I hope I remember to say, oh, and this would make a good Part B exam question. So that will be a hint, for example, that you might want to actually write out an answer for that. Now, you don't quite know how I'm going to ask it, but if you've got the information on a sheet, then that will make for quicker reference rather than picking up the textbook and going, okay, index, let's see, considered law cases applied. Oh, okay, page 92. Page 92. Oh, okay, here's the answer, because you just don't have time for that. Okay, so for example, the one I was just mumbling about is what the courts or judges can do in court when they're looking at cases offered by counsel. They can apply a BC case, they can follow up a case from another jurisdiction. They have to consider the cases as either helpful or not very helpful. they can actually distinguish some cases saying, no, it looks like it might have been applicable, but it really isn't. I distinguish it because it doesn't apply in this situation. And then they can look at I should apply this case, but you know what, I think it's wrongfully decided, so I'm going to overrule it. Okay, so that, hey, 5 things, good 5-mark Part B exam question. Okay, if you have any questions on any of that, you just email me. What I might do is, if it's a really good question, when I respond to you, I'll respond to everybody because they probably would have asked the question had they thought of it. All right, and then on the midterm exam, good luck.